When you file an appeal, you'll be asked if you want to designate a reporter's transcript in Part 2 of Form APP003. A reporter's transcript is a written record of oral proceedings, or what was said in the trial court. It is prepared by a court reporter. It's important to know that if you want to use anything that was said in the trial court to support your argument in the appeal, you must ask the trial court to send the Court of Appeal a record of oral proceedings. If you cannot get a reporter's transcript because there was no court reporter taking notes at an important hearing or at any of your hearings, there are other ways to provide the Court of Appeal with a record of oral proceedings. You can prepare an agreed statement or a settled statement. These statements are alternatives to a reporter's transcript. An agreed statement or a settled statement is another way to show the Court of Appeal what happened at a hearing where no court reporter was taking notes. You should know that these statements are not as good as a written record from a court reporter, and they are not always available. If you're planning to appeal and you know that there was no court reporter at a key hearing, you should start thinking about getting an agreed statement or a settled statement as soon as possible. In some ways, the two types of statements are similar, and in other ways, they're very different. First, we'll look at how they're similar. Both types of statements may replace a reporter's transcript by explaining what happened at a hearing in the trial court. Both statements include the facts and how the court decided your case. They sometimes include documents filed with the court. Both types of statements need to be prepared by you, the other parties, your lawyers, or a combination of people involved in your case. Now let's look at how the statements are different. An agreed statement is described in Rule 8.134. To use an agreed statement, all parties must agree on what the statement says, and all parties must sign the statement. The trial court will always accept the initial filing of an agreed statement, but there are specific rules about when an agreed statement must be submitted. It can be difficult to get all parties to agree on what the statement says, so most of the time you'll need to use a settled statement. A settled statement is described in Rule 8.137. Unlike an agreed statement, to use a settled statement, the parties do not all have to agree. However, in all cases, the trial court must review and approve a settled statement. And in some cases, you have to file a motion in the trial court to use a settled statement. To simplify things, let's discuss when you do not have to file a motion. A motion is not required if there was no court reporter taking notes of the oral proceedings, or if you have an order waiving your court fees and costs. If either of these is true in your case, you can elect in your Form APP003 to use a settled statement as the record of oral proceedings. If you want to use a settled statement for any other reason, you must file a motion to proceed by settled statement with the trial court judge that heard your case. You should know that the judge has the right to deny your motion. The motion to use a settled statement must be filed at the same time you file Form APP003. The motion must explain what hearing or hearings you're describing. The motion must also include specific information about why you want to use a settled statement. To learn more about when you can use a settled statement, read Rule 8.137b2a. If the trial court grants you permission to file a settled statement, you must provide a written explanation of what occurred at the hearing or hearings you want the Court of Appeal to know about. When preparing your settled statement, you're advised to use the form for a Proposed Statement on Appeal, Form APP014. You should include a description of everything that occurred at the hearing. If you do not include details about everything that happened, you need to explain why and also explain what you want to appeal. You may want to attach copies of documents discussed at the hearing, like trial exhibits that were admitted. The trial court will set a hearing to discuss the details of the settled statement. The other parties in your case will have an opportunity to review your statement before the court hearing. The other parties can object to any part of your explanation or propose changes to your statement. It will be up to the trial court to decide what the final version of the settled statement says. Once the trial court judge who heard your case decides what should be in the statement, the judge will certify the statement. After the judge certifies a settled statement, the trial court will send a copy of the final statement to the Court of Appeal and send a copy to the appellant. If the respondent wants a copy of the settled statement, he or she can get a copy from the Court of Appeal. There may be a fee. Finally, in some cases, the parties cannot reach an agreed statement, or the judge denies a request to proceed with a settled statement. If either of these happens to you, the next step would be to file an amended designation to proceed with only an appendix or a clerk's transcript. Thanks for watching this video about alternatives to a reporter's transcript. If you need more information about preparing an agreed statement or a settled statement, you can contact the trial court or visit our website.